first matter to come before the court this morning is State of Ohio versus Kashmair, Mingo. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time for rebuttal, I'm keeping the clock this morning. Let me know and I'll let you know when you're getting into that or up to that rebuttal time. Please don't use the names of any victims or minors as we are recording these arguments and they'll be posted on the court's YouTube channel. We've read the briefs. We're ready to see who you are.
May it please the court, I'm Mark Ludwig. I have the privilege of being appointed by Judge O'Farrell, the visiting judge at the trial of this case. He has, by the way, apparently forgiven me for all those DUI years ago. I do want to point out, if I would, in effect, publish one exhibit as we begin, and that's Exhibit 2, when you get a chance to look at it. It's the photographs of the three guys standing at the counter at the pawn shop. I would ask you to take a look at that, and when you think about a video of someone running away, you tell me how tall that person is. You tell me what color that person is. You tell me who that person is. If this court feels that there's evidence that you can do that, then I guess there's evidence that Cashy was there. The problem is, how do we know if Cashy was there? How do we know if Cashy didn't run away before shots were fired? How do we know he didn't get freaked out by that? Now, John Greven did one wonderful job at trial. The more serious murder charges are gone. We think those impact this case, and we've talked about inconsistent verdicts, and I'm well aware since 1860, I think I cited, it's a harsh road to go on inconsistent verdicts. We question the complicity in 4 ways. The inconsistent verdicts, there's no predicate offense, there's no evidence to support them, and the jury instruction was bad. Now, perhaps the only thing worse than that jury instruction was my argument on going at it and the basis of this record, that the complicity instruction and what was wrong with it standing by themselves is brutally ugly in these briefs. But that doesn't mean it wasn't wrong, especially when reading it coupled with the ideas of no predicate offense. I'm sorry for the predicate offense argument. I think it's right, but I think it does a lot of damage to the relationship of murder and aggravated robbery. And if this court's going to accept my premise, and I hope it does, but if it accepts that premise, the artful writing will have to be keeping that decision from ruining every case. And I don't think that'll be too difficult for this court to do, but it's extra work based on my argument. Cashy's 21 years old when this happens. No record. I will move to supplement because apparently the pre-sentence investigation didn't get in the record. But I'm not talking about it right now, other than general background of the kid when he was sentenced. He'll be 25 in February. He's done 4 years on these cases. I thought the able prosecutor and I could at least agree that the weapon under disability and the obstructing justice counts have been served, even if they weren't double jeopardy, and they were double jeopardy. But they've been served. Couldn't we agree that those are over with? Couldn't this court say that? In terms of the co-defendants, this court knows from its own records where they are. Davis is yet to be tried. He'll be tried in November, supposedly. He'll be tried in November. He will continue to watch. And Rankin, that mess is in your laps now. So we've got 3 people supposedly on the scene, one of which is free this moment. That's been difficult to explain to Cashy. we talk about standards of review, and I tried to find parts in this appeal where the state wasn't saying, well, you waived it, you didn't raise it right, you didn't, you know, to me, I'm trying to find places where we agreed and that we could factually, and at least what the law was, so we could argue that here and that kind of, but we have to argue the roadblocks first. I understand, you've got to make sure that things were preserved and all that. But we rarely talk about the merits. We talk about why we don't have to get to the merits. That may be a wonderful rule, but don't apply it in Cashie's case. Take a look at this case. This case, on the last thing, probably the worst assignment, is the possible conflict. No one in this room, in this record, can say Kashie knew about it and he waived it. And who are we kidding? On remand, if we get a remand, Kashie won't waive it. That's pretty sure now. A year ago, when this case was beginning, perhaps 2 years ago, Kashie might have waived it once it was explained to him. But now he might see it as the only way to freedom. What I'm saying is, it's possible. This record is clear, it's possible that could happen, that conflict existed. You folks don't deal with that. On a possible conflict, you look at a record. Now, will the record likely be Kashie doesn't want to waive it? That's correct. Will the record likely be it didn't hurt him? That's a possibility. But if it please the court, that should go back for a hearing on that with other reversals and guidance from this court. Guidance from this
And I
court.
take it on issue 1 on the conflict, if I understand the briefs. It was never raised before the court, and you're asking for discovery on that to go back. No one at any point in time said, look, we have this conflict, these folks are in their office together, and I'm concerned about that. That never came up.
No, never came
Because
up.
Kashie didn't know about it, your client didn't know about it to raise.
He did not, so he couldn't waive.
Okay.
I think the troubling thing is, you know, Your Honor, you already chastised me Tuesday for speculating the wrong way, but my concern is, this is how we treated a visiting judge. I don't think Mary Margaret would have ignored the fact of this membership. But this trial court did not have the opportunity. No one told him of this conflict. That's the important thing. That narrows this case. When we have a visiting judge, all of us have to be more careful that
So
judge.
you're indicating no one told the judge. When you
No
say
one.
him, no one told the defendant, no one mentioned to the judge, oh, and by the way, he had the co-defendant, and co-defendant has attorney so-and-so, and they're in the same office, just so you know, Judge.
And Eddie O'Farrell would have said, get him in here. Tell him about this, and we'll handle it now. And I think Mary Margaret Rowlands would have. But now, to say this court has to do it, that's wrong. It should go back with other guidance on other accepted assigned heirs. Thank you, Your Honor.
Thank you.
Good morning. My name is Rick Raley. I'm appearing today on behalf of the state of Ohio. I'd ask this court to affirm the convictions and the sentence that was imposed in this matter. I'll jump off from where we just ended with Mr. Levin's presentation about this conflict of interest issue. There has to be proof of an actual conflict based on controlling authority from the Supreme Court of Ohio. There is no proof of that in the record. This court cannot latch onto that to reverse and send us back for further development on that issue. In regards to the sufficiency arguments that are raised in the second and third assignment of error, there is a predicate offense. Aggravated robbery is quite clear. There is proof that This defendant and the co-defendants had stolen items from this victim the next day and tried to pawn those items. We have proof that the tall individual in the video is wearing the same pants and shoes as the defendant was wearing the next day in that video. We have proof that the defendant lied about his whereabouts on the day of the murder, showing his consciousness of guilt. We have cell tower records putting them in the area. We have evidence that they were together the next day in Barberton for an assault. This was a concerted action on these three people that we know were together at the time of this murder, and they bared the fruits of that actions by selling the items the next day. So I think there's quite enough for the jury in this case to go ahead and convict him on that offense. As to the obstructing and having weapons under disability charges, there is no grounds for this court to reverse those convictions because the sentences may have been served already based on jail time credit. That does not go to the merits of the underlying conviction. Those should be overruled as well. And if there are any questions, I just ask there be affirmance.
So your basic argument is that as far as the conflict, there's nothing in the record. If there's any claim about that, it'd be a PCR plus victim release claim or something else, but not on the direct appeal.
Absolutely, Judge.
Can I ask just on the face of the docket, because it's my understanding from the briefs that the attorney was not in the same office, the attorneys were not in the same office, but there was a movement into the office. I guess the question is it is apparent on the face of this docket that they were in the same office together, or do I have to search a different case to find that out?
I believe that's even a different case, Judge. And my understanding is, at best you could say it's an office share arrangement, based on my understanding of what's going on. But again, it's all speculation. That's not grounds for reversal. Thank you.
Your Honors, if it please the court, in terms of the speculation here about that, it's clear in this record that they were in different offices. Now, what docket do you have to look at? Do you only look at docket that's the B docket, Mingo, when they have filed documents under captions A, B, and C? All of the documents. Same document. We request this, put it under A, B, and C. Don't you look at C or A right now, because it ain't fair. Come on. They were filing everything under 3 numbers. Besides that issue, I spoke to Cashy before this case began, again, and I received permission for this, and I did want to say this, it's got absolutely nothing to do with this case or the next one I'll be in, but I wanted to say, today is November 9th. God rest his soul, it was my dad's birthday. It was also the day that I was sworn in 1974. This year I begin my 50th year, and last, I hope, by retirement, not death, in practice. I have had the privilege of appearing before this panel and 20 of the 28 on this wall. And I thank this court. I hope that this is a reversal for Cashy and a fair trial. My experience has got nothing to do with why he's entitled to that. Thank you.
So just, Mr. Ludwig, so I understand briefly the point you made about the A, B, and C defendants. To the extent we might be going for a different docket and see the addressing the attorney, we'd be looking all under the same case number, but under maybe a C docket or a B docket.
Yeah,
They're not going to a completely different case number and saying, oh no, look at Mr. Jones' case, a whole different case number.
Not at all. These are co-defendants.
Understood. Thank you.
And if they had separately filed, Your Honor, on using only one number in each case, I'd be even on shaky ground.
I understand what you're saying. Thank you.
Okay, thank you, Your Honor.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed by the clerk of courts to all parties in this appeal, as well as posted on the House Supreme Court website.